I'm very pleased to be asked to talk to you today about the subject of board formation, how a board of directors functions, and the overall view of governance of a corporation. For this talk, I have assumed that we have selected already a corporate form. Today there are available other structures. Historically there have been partnerships. Today we also have limited liability companies. But I've assumed that you have picked a corporation for some very important reasons. It is the historic form that provides limited liability to the maximum extent possible for the principles of the enterprise. It also is the form of structure that is the most accepted. And by having a corporate form, I believe you're giving the message to your potential future investors that you're serious in your business and that you're using a methodology that is tried and true, at least in the investment world. Many of the comments that I will make, however, about governance could apply to a board that's set under a limited liability company structure. I've also assumed that you've picked a California corporation, although many, if not most, of the comments that I'm going to make really apply no matter what jurisdiction you may select. But the most important thing is that I have assumed that this is a private corporation, that you are not seeking or able at the first moment to become a public company. A daunting thought, surely. I would comment that there are a whole variety of other regulatory oversights and rules that public companies must consider as they do their governance structures. These come clearly from securities laws, both federal and state, and the rules of a stock exchange should the stock ever be listed there. None of that, fortunately, is going to apply to you and your startup, but they do set the standards for what's considered good governance. So you may want to keep aware in the periphery of your mind comments that come as to how it is viewed as best practices for corporations to function. At its core, when the corporation is formed, that is done by the shareholders. The shareholders are the people who put in the capital, whether it's in the form of cash, an idea, efforts, whatever is described as the basic material with which the corporation is going to function. Those are the shareholders. The most important obligation of the shareholders is to elect the board of directors. They just must do that election once a year, and it certainly should be memorialized. The board of directors then has the obligation and the right to select the officers. The officers generally are the leaders of management. You will hear all of these terms. One person can and practically always will function in multiple roles and have multiple hats. As a shareholder, a member of the board, as an officer who is obviously management. But it's very important at any point in time to consider which role is being played at the time various decisions are being made. Adherence to the structure is part of ensuring that you're getting the maximum benefits from the corporate form. It is generally considered best that you have at least 3 directors. If you have fewer shareholders, it is possible to have a board of 1 or 2 people. But again, trying to convey a sense of experience, knowledge, best practices, 3 is considered a good idea. I would tell you it sounds very, very basic, but it is prudent to have an odd number of directors. Many startups have 2 people involved. They have pre-existing personal or financial interests, and they take their idea and they say, we'll go together and create this enterprise, and they end up as 50-50. Shareholders, 2 directors, etc. That is often a very unfortunate way to try to govern yourselves because you have no tiebreaker. We kind of learn about tiebreakers in kindergarten, and it is a very valid concept. I often think about a situation that I had where I would call him the principal of a two-person corporation. After it had launched, it had become very successful. I did not do the formation. But he came to see me because this was a company that had an idea that today would have gone out on the internet. At that time, it was at the beginnings of the home shopping network. And they have a product that took off. And these two buddies had taken what had been a general partnership without much thought. They had converted it to a 50-50 corporation. And I'm sure at the time they thought both of them were going to be equally involved. But as they become more successful, the other guy decided that he thought surfing was a really great thing to spend his time. And he rarely ever came to the office. He really wasn't involved in anything, while the client that came to see me was spending virtually 24/7 doing all the things you have to do in business, meeting with the advisors, raising the money, finding the new products, doing the filming, following the sales, etc., etc. And the two of them were taking the exact same compensation out of the company. And after a few years, that became intolerable to the man who was working. I always thought that rather than litigation, how much more successful it would have been had there been a third director who could have looked at the situation, and there could have been a motion passed that changed the compensation. Might not have changed the share ownership or even dealt with future buyout issues, but at least what they were paid for their services could have been adjusted. It's very important for the board to actually meet. Shareholders should meet at least once a year when they do this re-election of the board. The board of directors should meet as often as is needed. And when they meet, that should be memorialized. We call those minutes. The minutes would contain very practical but important pieces of information. Who attended? What was the date and time of the meeting? Where was the meeting? Were there any guests in attendance? And were there any decisions made? Those decisions are made by a board using motions. For those of you who may not have familiarity with that process, it may sound a little archaic, but it is very well accepted where someone makes a motion to make a particular decision, somebody else says, yes, I agree, I second it, and there's a vote. There also should be stated in the minutes that proper notice of the meeting was given or that the attendees have waived the requirement for notice. Minutes are an art. They're not a science. There's no reason that they have to be in any particular format, but they should be written. And whoever is acting as the secretary of the meeting or the secretary of the corporation should ensure that minutes are done. As your enterprise becomes more successful, as you're looking at bringing in future investors, one of the things they're going to ask to see are your minutes. Are you following the normal protocol? So it's a habit you want to start and follow. There is an alternative called unanimous consent, and it means just what it says. You can have a board make decisions without formally meeting as long as they do it all, i.e. unanimous, and it's a piece of paper that states this is the decision and everybody signs it. There is a subject that's somewhat off of the specifics of the board functioning, but is one that I think is so important. I want to emphasize it to you. And it's an area where the board should take some leadership, and that is discussing the subject of a shareholders agreement. Almost never do I see a startup actually take the time to deal with the issues that should be set out in a shareholders agreement. But it is at that point in time when you are the most in sync with each other that you have the best chance of coming to a reasonable agreement about how certain circumstances will be handled. The example that I gave you, what is the expectation for efforts? This is an area where I see a lot of discord. Who's quit their day job, so to speak, and they're putting full-time into this company? How are they going to be compensated? What is the expectation for when someone else is going to quit their existing job and become full-time or some substantial part-time into this business? And then what happens if they don't do that? What is the impact on their share ownership, let alone what their compensation will be? And that then leads to other issues of what happens, obviously, if someone passes away unexpectedly. Are spouses going to be acceptable into the enterprise, and in what role? What if someone becomes disabled? Rarely does a startup have the resources to buy what we call key man insurance, but there should be some basic understanding of what everybody's role is and how they can be counted upon. That's the purpose of a shareholder agreement. That is separate from a pure employment agreement, and sometimes one of the key discussions can be if someone quits and doesn't continue, do they get to continue to own their stock? And if not, what is the buyout right? The board names the officers, as I mentioned before. The officers would be the president, the secretary, and the chief financial officer. Often one person can have multiple hats. Again, from the perspective of presenting that you are serious in your business, I would encourage you to have more than one person in these different roles. Probably the most challenging and maybe the most important of your startup, in addition to writing a business plan, which I'm sure you'll hear about from other speakers, is trying to have an independent director. Is there someone other than you and your friend who's willing to put themselves in the position of serving as a director? Ideally, that person would be experienced in business, ideally experienced in the industry in which you have your venture. Well, they can bring not only their experience and knowledge, but contacts, and that sense of confidence that you want to build for your future investors, that you are worthy of their contributions to you. The biggest problem for someone coming on a board is, while we like to talk about corporations having protections from liability, there can be exposure for board members. Probably the one that's happens the most often and is impossible to protect is a corporation that fails to pay its withholding taxes. That's something that you're going to have to be able to really assure an independent director how they're going to get confident on that subject, because there can be personal liability for that. There also can be liability for litigation. Employment these days seems to be an area of ever-increasing litigation in which a director can be named. Clearly, you want to provide in your articles and bylaws for indemnification, where the corporation will indemnify your directors and officers from personal liability. Realistically, that's only as good as the worth of the corporation. So you write it, but that's probably not going to be enough. And you will hear about directors and officers insurance, again, rarely available to a startup company, and generally not something where people want to spend the money. Nice to have, but probably for later in your corporate life. So the role of the director, the board of directors, is to ensure shareholder rights. It is the enterprise in which the power to oversee and manage the corporation resides. So it's something in which the directors are supposed to consider the best interest of the corporation itself and the shareholders, not the board, in its decision making. This obviously can get very challenging in circumstance where you have limited people with multiple hats and where the formalities are the best way to provide some protection. In my view, the day-to-day single most important responsibility of the board is the selection of the chief executive officer. And they must not only use care in that selection, but they also have to do a periodic review of the performance of the chief executive, something that is relatively challenging but must be done. And finally, probably the most critical part is if there is difficulties with the performance of the chief executive, it is the board of directors' responsibility to deal with that problem. So the directors who are overseeing the business plan, they certainly want to be sure that they're looking at the strategic direction of the corporation, establishing periodic processes for review of the strategic plan, and obviously all the financials that go with it. The board has to act in compliance with certain directives. Generally, we call those the duty of care and the duty of loyalty. But I want to add to that, there is certainly an obligation in case law that the board will act with honesty and they will act with confidentiality. It's very important that the board understand that the information that they have concerning the enterprise is confidential to that enterprise. So the duty of care, pretty straightforward. The directors have to prepare, they have to attend meetings, they have to make reasonable inquiry as to what is happening in the business. The standard is what would an ordinarily prudent person or director do in those circumstances. The director has a right to all of the information of the corporation. Sometimes there's some confusion about that point, but directors have rights of access to the books and records of the corporation. The directors also have to comply with their duty of loyalty, and that means, as I said before, that they have to put the interests of the corporation and the shareholders above all others. The board does have the right to rely on information from others that is reasonable to rely on. And there is, for the benefit of directors, something called the business judgment rule that says the courts, for instance, will defer to the decisions of the board as long as the board has done reasonable inquiry and met some prudent standards. That does lead to the issue of self-dealing, another subject that's very complicated for startups because of the multiple hats. The best way to protect yourself from future arguments of self-dealing is to make full disclosure of the facts, to memorialize that full disclosure in your minutes, and to have the relationship that's being approved either approved by the shareholders or alternatively by a vote of the disinterested directors. Obviously, disinterested can get harder and harder when you have fewer and fewer directors. So your fallback is to have shareholder approval, and again, memorialized in the minutes. I would recommend that in addition to the other things about corporations that you've heard about from other speakers, that you invest in a simple book called The Robert's Rules of Orders. You've probably heard about it your whole life. It's a guidance for how you run meetings. Some people take them a little too far. They're not strict in that everything that's in it has to absolutely be done. But they are a good reference source for just how to conduct yourself when you're running a meeting. And you certainly should have one person who's designated to run your meetings. In a small corporation, often the president is also a director, and that president is responsible to run the meetings. If the president is not on the board, or you want to have an independent person running the meetings, you can also have a chairman of the board. Another subject are board committees. Generally, a small startup company would not bother with having board committees. There's just not enough people. and enough subjects. But hopefully as you complete and grow your enterprise, the time will come you'll have to start talking about subjects that you may want to delegate to subcommittees. Again, that's a motion of the board to establish a subcommittee, and you memorialize that in your minutes, and then the committee itself also memorializes that it has met and what it has done. Probably one of the first ones at some point that you'll have is a finance committee, and hopefully you will come to the point where you have to have audited financial statements, and when you're there, then you're going to end up with an audit committee as well. But that's when you're successful, and I do very much want to wish all of you great success. I know you've got great ideas out there, and hopefully all of these talks help you on the path forward.